Okay, I'm not sure how it happened, but I somehow ran across another Yuan Galt video, and I put a comment on there about offering to debate Juan on the income tax stuff. And before we get into any kind of debate, if he actually follows through or if he accepts the challenge, I wanted to clarify something that he had said to me when we were talking before he blocked me and quit talking to me. And that was definitions. He claims that, and I'm going to read specifically what he said here, but he claims that definitions are not really that important in law, that you just use whatever it is that's the common definition. And he's kind of, in my opinion, he's ignoring what the cases that he's putting forth are actually talking about, and I don't think that he's correct. In fact, we've got Supreme Court cases. If you watch the video that I've done recently on specifically on definitions, I cover what the Supreme Court has said about definitions that have been supplied in statutes. Now, you'll see that all of these cases that Juan's put forth are specifically talking about cases where there is no supplied definition. It's just a common word. And I don't necessarily argue that the Supreme Court or whatever court you're looking at is correct when they're trying to interpret something that wasn't defined in the law. What I'm arguing about, though, is where they have supplied a specific definition, and the Supreme Courts have literally said that where there is a supplied definition, you must use that definition. You can't just add things to it and try to, make it cover things that it doesn't specifically say, because when a statute has supplied or taken the time to redefine a word that we would commonly use, there must be some reason. And so you have to go with what has been supplied. And again, you can watch my definitions video if you're interested in seeing, more information on which Supreme Court cases and what I'm actually talking about. So let's take a look at what Juan has responded here. First off, one is not taught law from a dictionary. I never said that they were. They are used for first-year students to become familiar with the Latin phrases. I've never met an attorney who used a dictionary very much. And this is kind of interesting that he would say this, because if you go to the Supreme Court, look up any case you want to, 9 times out of 10, they'll spend hours discussing a single word. So it's kind of confusing how he's practiced law most of his life and never picked up a dictionary. I'm sure there are some areas of law where they may be used, but in my litigation experience of thousands of trials, not so much. Most statutes provide relevant definitions. If one is not there for a questionable word, one would first look to the plain common usage of the word. If none available, then you look in a legal dictionary. And I don't disagree with that statement. Now that's how I was taught to interpret statutory construction and how I have used definitions successfully for going on 50 years. You also have to know the legislative intent and scope by which the statute was constructed. Just focusing on definitions skews the interpretation. And I completely agree. I have no disagreement with that statement at all. So then he goes on. So, are you saying that your legal theory is based on how you interpret the definitions of words in Title 26? And just directly at Juan, no, that's not what I'm saying. I'm saying that it's not my interpretation. It's what is the definition actually saying when you read it. That's it. I'm not trying to add to it. I'm not even looking up anything in Black's Law or in any dictionary. I am simply looking at what the definition that was supplied actually says in the context of the federal government, because it is my contention that the federal government does not have jurisdiction in the 50 states, and there's plenty of Supreme Court cases to back that up. So these are definitely not my interpretations. These are the the statements made within the statutes themselves. So this is a quote. In interpreting the meaning of the words in a revenue act, we look to the ordinary everyday senses of the words. And this is Commissioner versus Solomon. This is a case. That is a quote. However, they're not talking about defined words within the statutes. They're just talking about words. He goes on to, and I'll elaborate on that in a second. He goes on, it says the words of statutes, including revenue acts, should be interpreted where possible in their ordinary everyday senses. And then he's got another one. The legislature must be presumed to use words in their known and ordinary significance. Common understanding and experience, the touchstone of the interpretation of revenue laws. Every single case that Yuan has put forth are not talking about words that were provided definitions. They were discussing common words that were within a statute. I didn't dig in to see exactly which statute they were even looking at, but they're all just speaking to words that are in the statutes. And I don't disagree with that at all. That's not my position. My position is if a definition is supplied, then you're supposed to use that specific definition. So I wanted to provide an example because Yuan likes to point out the fact that the word United States, the term United States, always includes the several states, that there's never a situation where it does not include the several states. So what I wanted to do, and I should have had this up before I started this, but let me jump in here. We're going to go down here to, let's see where we're at. Income sources. Let's go to, let's get down here. I think 3402. Here we go. So this is the federal insurance section. This is the FICA insurance. And I just want to point out a couple things. So this is the definition that was supplied in FICA. So it's specific to this one section of code. They defined a couple things. They defined the state as the term state includes. Now, again, you can go and add other things that are within the same family of the things that are being supplied to this definition, and that's perfectly reasonable. To me, it's weird because if you're going to make a statute that is supposed to govern people's lives, you would think you'd want to be pretty specific about what you're talking about. But I'll allow the fact that that's what they do. If something is within the same family of things, then you can add it in. So it says the term state includes the District of Columbia, the Commonwealth of Puerto Rico, the Virgin Islands, Guam, and the American Samoa. Now, those are all federally owned territories, or in DC. I mean, they're all federally owned. So if you were going to add something to the context of what they're talking about, it would have to be another territory. You can't just go add the 50 states, which I've got other videos where I go through and show where even in the USC, they refer to the states as foreign countries. So it's, to say that you can just all the time assume that the term United States always means the entire country, including all the 50 states, is just wrong. Because there are definitions that they have supplied where they actually say the several states. They actually bring them into the definition. But in all of the context within that's not true. In Title 26, when they're talking about the protection of your information, they actually define the term United States in that code section to include the several states. But nowhere when they're talking about income tax do they do that. It's always federally defined. So let's take a look at how they define the term United States. So the state is what we just looked at. The term United States, when used in a geographical sense, includes the Commonwealth of Puerto Rico, the Virgin Islands, Guam, and the American Samoa. So you'll notice the only thing missing from the term United States is the District of Columbia. But all of the other things that are listed in the state are also included in the United States, which is extremely odd because you would think the term United States would just say the states and the District of Columbia. But anyway, you see my point. They've defined this specifically to include only federal territories. Now, let's take a look at unemployment. If you go down here to unemployment, they define the United States and state. And in this section, they define the word state includes the District of Columbia, the Commonwealth of Puerto Rico, and the Virgin Islands. So this does not include those other territories that were specified in the FICA section. So can we just add them in? I would argue yes, because they're part of the family of the things that are listed here, but it is suspicious as to why this code section has left specific territories out where the other definition had them included. And then you'll notice here, the United States, the term United States, when used in geographical sense, includes the states, the District of Columbia, the Commonwealth of Puerto Rico, and the Virgin Islands. Again, they list the same things that they defined up here in the term states, they listed down here in the United States. So just to be specific, it says, it includes the states, which is this definition up here, and it's the District of Columbia, the District of Columbia, the Commonwealth of Puerto Rico, Commonwealth of Puerto Rico, and the Virgin Islands, So they literally define the states as the same definition as the United States, which is, again, extremely suspicious as to why they are doing this. So throughout the USC, if there's a section of code that literally includes the 50 states, the definition for state says that it includes the several states. But within the context of the IRS, the Title 26, that is never done except for the one place where they're talking about the specific protection of your information, because obviously it would be protected in all 50 states. And my only point here is that we have Supreme Court cases that specifically say that they actually point this out specifically within the context of the tax code, that words that have had their meanings supplied, you have to use explicitly what that definition says. You can't go just randomly decide that you want that thing to include something that it does not specifically state that it has. In addition to that, this argument about the United States or about the definition of wages or employment or any of the other stuff, these arguments have existed for over 30 years, probably more than 50 years, and not one single attempt has ever been made to go and change these definitions to make them more clear as to what they're saying. And as a result, the Supreme Court has also ruled that in that situation, you have to always lean on the side of the taxpayer, because if the code has been defined a certain way and nobody really understands what it's actually saying, and no attempt has ever been made to clarify that, not in the CFRs, not in Treasury decisions, not anywhere, then you have to assume that that word has been left that way for a particular reason, and therefore the taxpayer's problem with that particular definition, you have to rule on the side of the taxpayer. So I guess before we can really get into what the tax code is actually saying and having an actual debate, if Yuan will actually, get in a debate, he's already proven that anytime things get tough or somebody doesn't instantly agree with him, that he's just going to block them or start raising hell about things. But the point is that, and by the way, Yuan, your video, because the video that I commented on was you making fun of Yusuf L, because he never wants to debate anybody. And I do recognize the fact that you have debated a few people, not anybody that I would say is good at debating, but nonetheless, you have taken the time to debate people. So I'll give you that. But everything Yusuf El says is not actually incorrect. So he's a completely different asshole and, somebody to deal with on a different day. But I still stand by the fact that I'd like to debate you on income taxes, specifically not to get in an argument, because I legitimately would like to see if you can convince me that I am incorrect in my interpretation of the tax code, because I do not believe that you're going to be able to do that, but I am up for the challenge. So if you would like to have that discussion, I'm more than up for it, but we do have to come to some type of a consensus on the use of these definitions. And you alluded to it in your comment that you kind of agree that if a definition is specified, that's the definition you're going to use. But I just want that clarified for sure, that when we start having this discussion, because definitions are everything in the tax code. In fact, every single piece of statute that you read in the tax code refers you to some definition found somewhere else. So if your interpretation is that you just ignore those definitions and use whatever the hell you think you want to look up in the Webster's dictionary, then we're never going to be able to get anywhere. But if you concede that I am correct in my interpretation of how definitions are used, then I'd like to move forward with a debate on what the income tax stuff is actually saying. And again, I'm not going to pull up a Black's Law or anything else. We're going to keep it contextually within the different statutes and see what they actually have to say.